Hello everyone. Let us discuss about the MCQs that are based on the forensic medicine. You can check out the playlist that I've made on different objective questions from forensic, toxicology, medicine and much more topics like that. If you know the answer, do pause the video and comment the answers down. Okay, first question is open verdict in coroner's inquest means. There are different types of inquest: magistrate inquest, police inquest, and inquest by medical officer. One among them is coroner's inquest. What does it mean to have an open verdict by coroner inquest? So, the answer is judgment made in public, no verdict made, no case is kept pending. Option C will be the correct answer. Then, magistrate inquest is held in following cases except, as I have given the names of different inquests, one among them is magistrate inquest. Magistrate inquest is carried out by either your district magistrate, mostly it is carried out by district magistrate. It involves the cases where dowry death is observed, or death in police custody is observed, or death in jail, which are quite similar to death in police custody. But death due to anesthetic mishap, no. Magistrate inquest is not observed in this case. Now, the punishment of imprisonment up to 3 years and fine up to 50,000 can be awarded by. So there is quite a hierarchy where Chief Judicial Magistrate as monitor of the class, followed up by first class, second class, additional session judge, and all. So the fine of 50,000 and 3 years is awarded by first class judicial magistrate. Okay, the punishment could not exceed 3 years, whereas the fine also could not exceed the given amount. Then, in case of death in lockup, the inquest is held by the question that we read before this question. Magistrate inquest is held in all of the cases except, so here the answer of the question is already given in case you have paid attention to it. So, it is option number B, a magistrate. Then the next question, which carries more weight in a court of law? Among all of these, dying deposition carries the most weightage. Now, what is the difference between dying declaration and dying deposition is something that we should be mostly concerned about. A dying declaration is merely a statement which is made by a dying person about the cause of death. Probably they are trying to tell that who's the murderer, how their death is being caused, or something like that. So it is considered to be most reliable, but not as reliable as dying deposition, which is of most importance. Dying deposition is a formal statement which is made by a dying person under the oath, and it is recorded by magistrate. So just look how much more important it is and how much more importance it holds. Then it is done often in the presence of the accused's lawyer. While both are statements made by dying individuals only, but the dying deposition is more formal, which is why it holds more importance. Okay, I hope the difference is very clear to you. Then again, question from quite same topic. Dying declaration can be received by, so it can be received by all of them, either it is a medical officer, lawyer, or the police personnel. Then dying deposition is recorded by magistrate himself. Option B will be the correct answer. Which of the following is a cognizable offense, and which is not a cognizable offense? Because the question is asking about the exception. What is a cognizable offense? Offenses which are quite heinous in nature, offenses where arrest is made immediately without receiving some kind of warrant or anything. So obviously among all of these, robbery, murder, rape are extremely heinous in nature, as we know. But the option number D, which is attempt to suicide, it is not a cognizable offense. Medical legal autopsy is required to be done by the permission of the relatives, medical superintendent, police, magistrate. No, the answer is police. Police need to give their permission in order to carry out the medical legal autopsy. Then 21st question. Which of the following is true about oath? So, if you know, oath is compulsory and binds witnesses for the evidence given. It gives kind of weight to the evidence that is being presented, which is why it is must, it is compulsory, it is necessary. Fine. I hope these questions are quite easy and you must be able to solve it. Let us have a look at more questions like this. Medical certificate is what is a medical certificate? Something that is being awarded to the prisoner, to the court, to whom? Then the option A will be the correct answer. It is a kind of documentary evidence. It holds huge amount of important. Look, it is not some evidence, it is not some hearsay evidence. Hearsay evidence means which is being heard by somewhere, which you got to know from somewhere, from third party or something like that. Payroll, obviously not. The inquiry into the circumstances of death is called, the term which is being used since beginning of this lecture, inquest report. The inquiry into death is termed as inquest. Inquest can be of any type, by magistrate, by police, by coroner, or by anyone. Then an arrested person can request the magistrate for medical examination of his body by a registered medical practitioner. As per this is based on CRPC, Criminal Procedure Code, or Code of Criminal Procedure, which is now changed to Bharatiya Nagrik Suraksha Sanhita, that is BNSS. So this is an old section and question must be framed back then. Answer would be section number 54, which gives the right to an arrested person. So the medical examination could be carried out. Now some more questions like this. The sentence awarded by a court may be enhanced by, so the sentence whatsoever awarded, if the sentence is awarded by High Court, it can be enhanced by the Supreme Court, the higher court than High Court. So the answer would be higher court. Because look, if some sentence is awarded by Supreme Court, then I don't think High Court or Magistrate Court can make any significant changes in that, isn't it? Exhumation is usually done in which time? What is exhumation? Digging out of the corpse is simply exhumation. It could be done for further examination, or in case the police is unable to solve the case, or CBI inquiry has been held. So in such cases exhumation needs to be carried out, because in every religion there is no significant rule as such that burning of the bodies must know. People usually don't do that in other religion except in Hinduism, and in much more religion it must be done. I don't know much about it. So the answer is option number A, in early morning. The time limit for ordering of exhumation in India. These questions are related to exhumation. So there is no significant time limit as such, based on which the order of exhumation has to be passed by the higher authorities. Okay. I hope the questions are clear to you. You liked the session as well. And I will prepare more lectures as such based on the different topics of forensic medicine and forensic toxicology. Till then, do subscribe our channel and don't forget to share this lecture with your friends. Thank you so much.